Did you know that when a medical expert comes in to testify on behalf of an injured victim in a medical malpractice case, the defense lawyer is going to have a stack of transcripts of what that medical expert has testified to in the past? You want to know what this is all about? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. When we bring a medical malpractice lawsuit, we are required to have a medical expert who confirms that we have a valid basis for a case. And now, as we get close to trial, we have to notify the defense that we have retained a board-certified medical expert in a particular field, and now we have to tell the defense exactly what this witness will be talking about. We also have to provide their credentials. We don't have to give the name, and we do not give their name. But using computers, using certain computer software, just like we do, the defense will always go ahead and try and identify who the medical expert is. And they will likely succeed. Now, once they've identified who the medical expert is, what's the first thing they're going to do? They will go into their data bank to determine when and how many times this expert has testified before. And then they will do everything possible to get transcripts of every time this expert has testified. And why would they do that? Because they want to scour every single piece of testimony, every single word this expert has ever uttered, to determine if there's anything in there that contradicts anything they're going to be saying in this case. They want to dig up dirt on this expert. So now, if this is an expert who has testified many times before, the defense literally will get stacks and stacks of transcripts, and now have to spend days and weeks going through those transcripts to determine whether or not there's something juicy in there that they can use to cross-examine the doctor at the time of trial. And more likely than not, they will find one or two key pieces of information that either contradict something they've said before, and now that they're saying differently, or something that they can use as a collateral attack, which doesn't really focus on the issues and conclusions the expert is talking about in this case, but rather is something that has nothing to do whatsoever with the facts of the case, but has to do with the doctor personally. And that could totally destroy his credibility. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on in a medical malpractice case here in the state of New York. You know, I realize you're watching this because you've got questions or concerns about your own particular matter. If you're contemplating bringing a lawsuit and your matter happened here in New York and you've got legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, G-E-R-R-Y, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.